Hello, my name is Douglas Guilfoyle, and in this recording I'd like to introduce our unit on the history and institutions of international criminal law. So in this unit we'll be conducting a brief review of the history of international criminal law from early origins through to steps towards the Rome Statute of the International Criminal Court, which will be the focus of the next of these presentations. We'll move through a lot of the material relatively briskly, and we'll have the opportunity to explore it more in class. I should also note that a lot of the material in these slides was first prepared by my colleague Dr. Joanna Kyriakakis, and I'm very grateful for that. All right, so let's begin. If we look to the history of international criminal law, we can see that it's not an entirely new phenomenon. The idea that there should be laws governing war are present in, for example, the works of Sun Tzu and his work on the art of war, calling for a requirement that captives be treated well. Certainly we also see in the Hindu tradition concepts around the treatment of foes in battle and permissible weapons, and we certainly see ideas in the Greek and Roman tradition as well of laws governing the conduct of war. Now, the fact that one has law governing war is a separate thing from the idea that there might be war crimes trials for the violations of such laws and rules, but nonetheless it's obviously a necessary precursor. The European tradition also encompasses the idea of just war theory, so there are limitations present in natural or divine law on the ability of a sovereign state to wage war. And the basic steps of just war theory require sovereign authorization, just cause, and right intent. Now this led in particular to, in 1474, a famous incident in which there was a trial of Peter von Hagenbach, a European ruler who was despised by neighbouring states and cities for his cruelty and his conduct and mismanagement of armed conflict. Now, we then, while that's often seen as the first war crimes trial, in a general sense, it has relatively little influence on subsequent developments. Where we do see historical precursors to the modern law, at least beginning, are the works of early international law scholars such as Vittorio Suarez and Gentili, codifying concepts of the laws of war, but drawing on a wide variety of both legal and theological materials. The most comprehensive such effort is Hugo Grotius's The Law of War and Peace, and Grotius, for a number of his works, is often regarded as the grandfather of modern international law, at least in the European tradition. We then see a further series of treaties attempting to codify the laws applicable in armed conflict, and in particular we see the Hague Conventions of 1899 and 1907 governing war on land and sea, and then the 1949 Geneva Conventions that we'll return to in quite some detail when we look at the law of war crimes. There's also a growth during this period of national military codes setting out the laws for the conduct of war, and in addition conduct which might be subject to punishment in the event of its breach. The most famous of these is the Lieber Code, issued in 1863 as part of the US Civil War, and we do see a number of war crimes trials through the 19th century. However, for our purposes, the history of international criminal law begins to gather pace after the First World War, and in particular there is a report released by the so-called Commission on the Responsibility of the Authors of the War that looked for evidence as to who could or should be punished on, one should note, the losing side of the German powers and its allies, and the Versailles Peace Treaty provided for trials in a number of clauses. So, for example, Article 229 stated that persons guilty of criminal acts against the nationals of one of the allied or associated powers will be brought before military tribunals of that power. So it provided for prosecution by states other than the national state of alleged offenders, and it also provided for the possibility of a collective military tribunal governing cases where persons' acts were committed against more than one of the allied or associated powers. This led to the so-called Leipzig trials, which are actually conducted by German courts in Germany. These trials were problematic in that only a very limited number of trials proceeded, and they were marked in particular by a very high rate of acquittals, extremely lenient sentences, and extraordinary bias shown by the part of German judges towards German nationals, particularly superior officers accused of war crimes. There was also a provision in the peace treaty concluded with the Ottoman Empire, the Treaty of Sèvres, which contained much the same terms, but these were then substantially revised under the revised peace treaty of Lausanne. And in effect, restoring peace with the defeated powers required that the scope of the anticipated trial program be greatly reduced, or indeed, in the case of the Treaty of Lausanne, eliminated altogether. So, we can see that through the 20th century there are a number of international criminal tribunals established, and each of them is different. There is no single model for an international criminal tribunal. And we can see a series here on the left of international criminal tribunals: the Nuremberg Tribunal, the Tokyo Tribunal, the International Criminal Tribunal for the former Yugoslavia, and the International Criminal Tribunal for Rwanda, as well as the International Criminal Court. We also see a number of so-called hybrid or internationalized courts, courts combining both national and international elements, such as the Special Court for Sierra Leone, the tribunals established for Iraq, special panels within court systems established in East Timor and Kosovo, the Specialist War Crimes Chamber in Bosnia and Herzegovina and Serbia, and the extraordinary chambers in the courts of Cambodia and the Special Tribunal for Lebanon. And we'll take a look at, for example, the Special Court for Sierra Leone and the extraordinary chambers of the courts of Cambodia a little later in these slides. Turning then to the program of trials conducted after the Second World War. Now, whether there should be trials at all was to some extent controversial, but in the end the rationale was that the Axis powers had been defeated by the Allies, which included a significant number of democratic powers, and that due process of law was consistent with their values. Of course, the Allied powers also included Soviet Russia, which had a rather different concept of how the rule of law or rule by law should work. It was hoped that the trials would have an educative role and demythologize certain elements of the Nazi state, though the extent to which this was achieved at the time is perhaps questionable. There was the desire to lay an historic record and also set out, in effect, the facts justifying particularly US involvement in a European war. And there was a sense that the broad and collective nature of the crimes warranted some sort of universal response. But we should also note that there were political factors at play. There was a concern that summary executions could create martyrs and pave the way for a return of factions associated with Nazism, and also plans for a harsher peace simply failed. So the United States was always going to have a very large say in the post-war arrangements made for occupied Germany, and Secretary Morgenthau of the US Treasury advocated a very harsh peace, essentially the deindustrialization of Germany, its more or less permanent occupation, and its reduction to effectively an agrarian society. When it became clear that public opinion would not support such a harsh peace, then the plan put forward by Secretary Stimson, the US Secretary of War, which involved trials, was the one ultimately taken by President Roosevelt to conferences with Premier Stalin and Prime Minister Churchill about how post-war arrangements would be made for Germany. So in setting up the International Military Tribunal at Nuremberg, the famous so-called Nuremberg Tribunal, to try the surviving senior Nazi leadership, there were a number of problems that needed to be addressed in the construction of those trials. The first question was, who were you even going to put on trial? Not every possible leader could be put on trial, and there was a question as to how one would represent the various aspects of the Nazi state, which goes straight to the question of selectivity, which is consistently a problem for international criminal trials. You will never be able to prosecute everyone involved in international criminal offences, so how do you choose those you will? There was the pragmatic problem of how do you reconcile four different legal systems, two common law systems, the US and the UK, the French civil law system, and then the Soviet system of justice. There were significant problems to address in terms of defining the crimes over which the tribunal would have jurisdiction, and indeed a question mark over whether those crimes were clearly defined at international law at the time of their commission, or whether the defendants would be able to argue that they were being prosecuted under novel retroactive law. There was also going to be a problem of the defence of superior orders. This had been acknowledged as a defence, for example, at the Leipzig trials, and if everyone could, as it were, pass responsibility to their superior, in theory this could vest all responsibility for at least German war crimes in Hitler, who was, of course, at this stage dead. And then there was the further question of how are you going to put on trial, in effect, an entire state that you've branded as criminal. So first there's a question of how are you, as a matter of legal and criminal theory, going to connect high leaders who did not themselves conduct executions or atrocities with crimes that might be physically and structurally remote from them. And also, what are you going to do with the various organizations that formed part of the state, which were branded as being involved in the crimes of the regime? Now, we'll go into both of these questions in more detail later, but in essence, a US theory of joint responsibility for crimes committed in the course of a conspiracy became the basis of the charges, so a conspiracy to wage aggressive war and a conspiracy to commit other crimes. The idea being that all participants to the conspiracy would be liable for all of its results. This was somewhat controversial at the time, as it was a notion alien particularly to French and Russian law. Also, the Nuremberg Tribunal was to have a power to declare certain organizations to be criminal, and then there could be subsequent proceedings before other tribunals conducted by national authorities in the different zones of occupation. And the essence of those proceedings would be that people would be accused of membership in a criminal organization and could then lead evidence that they were either not members, or they were members only involuntarily, or they were not involved in the crimes of that organization. And that formed something of a linchpin of what are often called the subsequent proceedings. So proceedings that followed the major international Nuremberg trial before military courts run by variously the US, the United Kingdom, France and Russia. And we'll note in particular some of the US trials. So the Nuremberg Tribunal itself was set up by the so-called London Agreement of 1945, and that included within it the Charter of the Nuremberg International Military Tribunal. And this was to have jurisdiction over the defeated powers in respect of the crime of aggression, of waging aggressive war, crimes against humanity, a newly defined category, and war crimes, a group of crimes more commonly understood. It was also said that there could be no immunity before the tribunal in terms of one's role as head of state or responsible officials in a government department could not shield one from responsibility, and also defence of superior orders was specifically excluded. There was finally the question of how to resolve the various legal systems implicated in the trial, and simply the Charter said that a practical and non-technical approach would be taken. Now, the fundamental principle that the tribunal espoused was that crimes against international law are committed by men, not abstract entities, and only by punishing individuals who commit such crimes can the provisions of international law be enforced. And we'll consider as the course goes forward the extent to which that is true, but we should certainly note now that not every breach of international law per se results in individual responsibility. Nonetheless, this articulation of a general principle of international law creating responsibility for individuals where they breach certain criminal principles was an important development at the time. So, as we noted, the IMT Charter also made provision for certain organisations to be declared criminal. That is listed in Article 9, and that provided the mechanism I've outlined for the subsequent proceedings. So Article 10 then foreshadows those subsequent proceedings, saying that national authorities can conduct trials on a charge of being a member of an organisation declared criminal under Article 9. All right, we'll briefly note that there were also trials at the end of the Second World War conducted in Tokyo concerning crimes committed by particularly Japanese forces in the Eastern Theatre. Again, crimes against the peace, the crime of aggressive war, war crimes and crimes against humanity fell within its jurisdiction. The Tokyo Tribunal was modelled closely on the IMT Charter, but was more severely criticised as being marred by substantial procedural irregularities and also a claim that it represented victors' justice. There were also significant problems of cultural differences in assessing the evidence, where, for example, the judges took the view that members of the Japanese War Cabinet had not sufficiently vigorously protested aspects of a criminal plan, when in reality, in terms of Japanese culture, they had expressed themselves extremely vigorously, but the point was, as it were, lost in translation. Now, I've already foreshadowed the role of the so-called subsequent proceedings. These happened in German-occupied territory under Control Council Law No. 10, a law passed by the government of occupation. It allowed the Allies as occupying forces to prosecute German nationals. Occupied Germany had been divided into 4 zones administered by the different major victorious powers. These were conducted as national prosecutions patterned on the IMT Charter, and in particular the US prosecutions left a substantial judicial record which has been significant in later developments. So you'll see often footnoted or referred to in the literature a number of the subsequent trials listed here, particularly, say, the Pole case on slavery, the Justice case on the responsibility of government officials, and the Ministries and High Command case on a similar basis, and the Einsatzgruppen case on war crimes and crimes against humanity, but also the potential role of civilians closely associated with the war effort where they knew they were contributing to illegal activity. The industrialists' case and the Pole case are also significant. Then very little happens between 1955 and 1992. To some extent, this is the result of the Cold War, the stalemate between capitalist and communist powers, and particularly the United States and the USSR. So international prosecutions have largely wound down by 1955, and no new tribunals are established. There were some developments towards a permanent international criminal court. There's a reference to an international tribunal in Article 6 of the Genocide Convention of 1948, and the International Law Commission starts work as early as 1951 on a draft statute for an international criminal court. And there are also some very significant domestic prosecutions, such as the Eichmann trial in Jerusalem. Nonetheless, it takes until 1992 for there to be further relevant developments. So, in particular, the United Nations Security Council sets up the International Criminal Tribunal for the former Yugoslavia and the International Criminal Tribunal for Rwanda in the early 1990s. So this slide outlines at a very high level the three principal branches of the United Nations: the Security Council, the executive branch, the General Assembly, the assembly of all member states of the United Nations, and the International Court of Justice as the principal judicial organ. So the tribunals for Yugoslavia and Rwanda were established as subsidiary organs of the Security Council, not of the General Assembly or the ICJ, and we'll explain how that came about. Essentially, Articles 39 to 41 of the UN Charter allow the Security Council to determine the existence of a threat to the peace, a breach of the peace, or an act of aggression, and decide what measures should be adopted to maintain and restore international peace and security. And when acting under its powers under Chapter 7 of the UN Charter, all UN member states are obliged to give effect to those resolutions. So in 1993, the Security Council establishes a charter for the Tribunal for Yugoslavia in Resolution 827, and a charter for the International Criminal Tribunal for Rwanda in Resolution 955. Now, both of these resolutions were passed on the basis that the situation in the former Yugoslavia continues to constitute a threat to international peace and security. So as at 1993, the wars within the territory of the former Yugoslavia, as it dissolved into a series of new states, were continuing, and crimes committed across ethnic, national and religious lines were continuing to occur. The genocide in Rwanda had concluded by the time of the establishment of the tribunal, but the legacy of the genocide in terms of displaced persons and other causes of regional instability was seen to constitute a threat to international peace and security, justifying the establishment of a criminal tribunal. Now, the tribunals have different fields of competence. The ICTY had powers in respect of crimes committed on the territory of the former Yugoslavia after a particular date. So it had an open-ended temporal mandate, whereas the Tribunal for Rwanda had a closed temporal mandate, only relating to the events of 1994, and it couldn't look at previous or subsequent events, and again looked at the territory of Rwanda and the actions of Rwandan citizens who committed crimes in adjacent states. In both cases, these tribunals had primary jurisdiction. Their jurisdiction took precedence over any national courts with jurisdiction over the same offences, and these tribunals had jurisdiction over war crimes, crimes against humanity, and genocide. So the additional jurisdictional competence is genocide, which was not tried at the Nuremberg Tribunal, but the crime of waging aggressive war is absent from their statutes. Now, we'll go into more detail later about the structure of the tribunals for Yugoslavia and Rwanda, but it's notable that they had a common appeals chamber seated in The Hague. Each then had its own trial chambers located either in The Hague or in Arusha, and before going to trial, certain matters would be dealt with in a pre-trial phase, and while there was a single overall prosecutor initially with responsibility for both the running of proceedings in the ICTY and the ICTR, those responsibilities were later more clearly separated. So there were separate prosecutorial officers dealing with each of the tribunals. We then come to hybrid or so-called internationalized courts. These will have a mixture of national and international features. So most typically, these have been established within national jurisdictions to assist the prosecution at a national level of international crimes, but involve international resources and very often international judges and prosecutors. So you'll see a mixed composition. The court processes will include both national and international judges and prosecutors. Often they have jurisdiction over both international and national crimes, and they are frequently set up as part of the domestic legal system, as in, say, East Timor, but sometimes as a freestanding international court, or a court founded to some extent in an international agreement, such as the Special Court for Sierra Leone. They can be established in various ways by agreement between the UN and a state, so an agreement between a state and an international organisation, under international administration, so where post-conflict societies are being directly administered by the United Nations, or they can be established by the state itself with a degree of international support. So if we look quickly at the Special Court for Sierra Leone, it consists of a trial and appeals chamber. It is staffed by a majority of international judges. It had jurisdiction over those who bore the greatest responsibility for serious violations of international humanitarian law and Sierra Leonean law. It had no jurisdiction over children, and it had jurisdiction over certain international offences and Sierra Leonean offences, including crimes against humanity, war crimes, the serious abuse of female children, and the deliberate destruction of property. By contrast, the extraordinary chambers in the courts of Cambodia were set up outside the UN system, though supported by it. The extraordinary chambers were established within the Cambodian court system, but as a standalone mechanism without further appeal rights, for example, to the ordinary Sierra Leonean criminal courts. These chambers consisted of a pre-trial chamber, which to some extent followed a civil law criminal model, as Cambodia had inherited its criminal justice system from France, followed by a trial chamber and then a Supreme Court chamber for appeals. The rules of procedure applicable in the courts were a hybrid of international model rules and Cambodian rules of procedure, and ultimately the governing statute for the ECCC was adopted both as Cambodian legislation and as a resolution of the General Assembly of the United Nations. In contrast to the Special Court for Sierra Leone, while there are both international and national judges, here the Cambodian judges are in a majority, but certain decisions of the chambers are subject to a so-called supermajority in which at least one international judge must concur. And in terms of the development and investigation of cases and prosecutions, these involve co-prosecutors and so-called co-investigating judges. So this, as intimated, follows the French model of having a juge d'instruction who supervises the initial criminal investigation, and the co-prosecutors and co-investigating judges had one each of a Cambodian national and an international representative. All right, that concludes what I had wanted to say by way of introduction to history and mechanisms, and the next of these presentations will go over the Rome Statute of the International Criminal Court in some detail. Thank you for your attention. I hope you found this interesting.